So good morning, everyone. This morning we'll be sharing with all of you important information about personal liability insurance, which is also sometimes referred to as malpractice insurance. Today, I'm pleased to have Derek Liu, which is the President and CEO of ProLink Insurance with me today. ProLink is a longtime CDAA partner in providing various types of insurances to our CDAA members. Welcome, Derek.
Thanks, Stephanie. Great to be here.
So Derek, could you speak up this morning a little bit about what is malpractice or personal liability insurance?
Thanks, Stephanie. It's a great question to start with. It's a really unique insurance policy that provides each dental assistant who is a member of CDAA with their own personal legal protection if a client, patient, caregiver of a patient brings an allegation of professional negligence against them. And the third party, though, doesn't actually have to be an actual patient. It could be a parent, it could be a caregiver, or really any third party who relied on the services of you as a dental assistant. And so you can think of malpractice insurance almost like having your own lawyer on retainer, because the policy covers your legal defense costs. And so if you're found guilty of negligence, then the policy also covers the damages that are awarded to a third party, and that would be up to the coverage amount under the policy, which is $2 million for one claim.
Okay, thank you for that. And you talk about malpractice insurance, but are there different types of malpractice insurance?
Yeah, in terms of different types of malpractice insurance, it's specific to what you do as a professional. So the malpractice insurance is specific for dental assistants versus a dentist or versus a dental hygienist. But the other big difference is the way the policies are structured. And a big benefit of the CDAA policy versus other policies is that you have an occurrence-based policy, which really just means that you have coverage in place for a claim as long as you purchase the policy while you are a practicing DA.
So that means are dental assistants protected by their insurance even after they stop practicing? For example, if they retire or leave the profession?
Yeah, that's a great way to look at how the coverage works, and it's a big benefit. The answer is yes. Once you stop practicing, that could be for a number of reasons. You could be on paternity, maternity leave. You might leave the profession and do something else, or you might retire. And when you do that, big benefit is you do not need to worry about buying coverage after you stop practicing, because you have coverage in perpetuity for all the work you did in the past, as long as you kept your policy consistent and in place year to year under CDAA.
Okay, great. What we've heard from a lot of our members is that employers are telling their staff that they hold practice insurance and that this practice insurance protects dental assistants in the event of a malpractice claim. Could you comment on why that insurance is not sufficient to protect dental assistants, and how only being covered through an employer's insurance could put a dental assistant at risk?
It's a really good question. I'm glad we're diving into it. The primary concern that we have when you rely on the owner of a dental office, and that might be the dentist who's been the practitioner for many, many years, but it could also be a larger corporation, because we know that private equity firms and larger aggregators are buying a lot of dental offices and dental clinics across the country. And so you don't often know necessarily who holds the policy for the practice or the clinic where you work. And so from our view, it's really difficult to obtain an update from a dental owner around what you're covered for, what you're not covered for. And so if you have a claim and an allegation where you're added into that allegation, that statement of claim, you're probably listed along with maybe the dental hygienist, the dentist, and maybe the corporation that owns the organization or owns the dental office. If you don't have your own lawyer looking out for your interests, then that uncertainty becomes really stressful. It's going to be very difficult for you to get updates from the corporate owner of that policy. But if you have your own personal protection, then you have your own lawyer that's been appointed for you, who's focused on defending your interests, and your reputation is not really focused on the reputation of the dentist or of the clinic and dental office owner.
That's definitely a huge benefit. A very a good way to look at it, I guess, is a good way to make sure that you're protected to the maximum that you can be.
Yeah.
When you talk about a claim against a dental assistant or a dental office, could you give us some examples of situations where a personal liability insurance would kick in?
Sure. The coverage is there to protect you for an allegation of negligence in your role as a dental assistant. And the allegation could be a financial loss that they've incurred. And that could be maybe around the billing practices. Maybe you made an error in the way you were providing information to their health insurance organization, to their employer-sponsored health insurer. And so now they have not had claims covered, or they've had claims declined. The other issue you can run into, of course, is, and usually more serious, is bodily injury, or someone has suffered an actual injury. And that might be them falling when coming into the clinic itself and feeling that the clinic was not in a safe environment, the classic slip and fall because the water was not off the floor. It could be related to getting into a chair. It could be the instruments that were utilized. And if they feel that the dental assistant, and when I say feel, that is a personal injury lawyer who is going to feel that, you know what, we need to name everybody who was remotely involved in serving you: the dental assistant, dental hygienist, and the dentist. So we're going to name everybody in this. And so the types of allegations you get can be very far reaching, even though the dental assistant may have only been involved in a very small fraction of interaction with that patient overall. And the reality is you have to issue a statement of defense. And so issuing a statement of defense is going to cost you somewhere between probably $12,000 and $15,000 a year. And under this policy, like I said before, it's like having a lawyer on retention, and that lawyer will issue, and the insurance company will pay for them issuing that statement of defense to protect you and hopefully exonerate you and remove you from that claim.
So that's great. Thank you for clarifying the types of insurance and the importance of holding personal insurance policy. But let's talk a little bit more now about the details of the CDAA program. So can you talk a little bit about what is the current cost of our program per year? And perhaps you could talk about its level of affordability in relation to other similar programs.
Cost benefit is always a big part of an association program. And the discounted structure in this program is something that you just can't beat across the country, no matter where you're going to try to find a malpractice policy geared to dental assistants. And so the cost of the policy for CDAA members is $16.50 per year. And that coverage is giving you $2 million for one claim and a total of $3 million in the year. And when we say $2 million, there are two important parts to the coverage. There is the legal defense costs. So that's hiring the lawyer. Insurance company takes care of hiring the lawyer. They get lawyers who are professionals and focused in professional malpractice. They're usually anywhere between $450 to probably $750 per hour. So those costs can run up very quickly. The insurance company is covering your legal defense costs, and then they're covering damages that you'd have to pay to a third party as a result of a court-awarded settlement. And that can be hundreds of thousands of dollars. And so you get to that total of $2 million for a claim. And then if you had two claims in a year, it gives you a total of $3 million for the year.
So my next question would be then, what happens if a claim results in an amount that is beyond the threshold of the policy?
Yeah, it's a great question after we just provided that background related to you get $2 million of coverage for one claim. So let's use a scenario. You have a claim and it's a bodily injury claim where someone has suffered serious injury, and your legal defense costs, let's say, are $500,000, which in a very serious personal injury situation could be that could be a denomination amount that's incurred by the insurance company. Then you have $1.5 million left to pay damages, because remember the total is $2 million for one claim. And let's say that the damages are $1.7 million. It would mean that you would be funding $200,000 on your own. Now, I don't want to be a fear mongerer because we have not had a claim in the program that ever exceeded $2 million, but it is possible, and it has happened in other healthcare practitioners and other areas of professional insurance where we have seen a claim go above the threshold of the policy, which is $2 million in the case of dental assistance.
Okay. Also, you mentioned about having continuous coverage. What were to happen in the situation where a dental assistant had a break in their insurance coverage? Let's say they didn't renew or they didn't renew on their renewal date. And then a claim was put in related to that gap in coverage. Could you talk a little bit about what that would mean?
Good. I'm going to use an example in this case, Stephanie, as well. But the answer to your question is there is no coverage for a claim that's brought against you if it relates to a time when you did not have an active malpractice policy or CDAA malpractice policy. But an example might be the best way to help you understand that. Let's say that a dental assistant, for whatever reason, they let their CDAA policy and the membership lapse for 2022. And then they purchase coverage again in 2023. A claim comes against and names the dental assistant sometime in 2023. Now you have a policy in place in 2023, except the allegations relate to services that you provide as a dental assistant in 2022, when you did not have an active policy. The insurance company is not going to defend or even respond to that claim because you had a gap. You've got a policy in place in 2023 that doesn't actually respond to 2022 because you had no policy in place in 2022 when you were providing the services that resulted in that claim. Does that help understand the timing?
That does. Thank you for that. But I have a subsequent question. So we know that dental assistants are very, very busy and everybody's life is very, very busy. And sometimes that renewal date comes and goes, and there might be a lag of 1 month or 2 months or 3 months between the time when your one policy ends and your new policy begins. So could you talk about that? Would that be the similar situation?
Yeah, and those, we absolutely see it happen sometimes where, and it's not just healthcare practitioners who obviously are some of the busiest people that we're going to see given what's going on in Canadian culture and what we're going through with the pandemic, but other professions too, where they miss their membership renewal date and they miss it by 90 days. They're just late in coming back. It's the same scenario I just went through. That would be unfortunate, but yes, if someone didn't renew their membership in coverage for a 90-day window because they were just late in doing so, and then a claim comes in the future that relates to services that you were providing during that 90-day window when you had no coverage and no membership, the insurance company unfortunately would not cover it.
Okay, great. Well, I hope that doesn't happen, and I hope people hear how important it is to renew on your renewal date and keep that coverage continuous. The other question I had is, what happens in the event that a dental assistant is participating in an activity that is outside their legal scope of practice? How would that impact their malpractice insurance coverage should an allegation be brought forward?
Thanks for asking that question. It's one that we really want to make sure dental assistants are aware of. So the policy is structured and priced on a group aggregate basis for all CDAA members, and is structured on your services as a dental assistant. So if you stretch into dental hygienist work, or if you are doing things totally outside of being a dental assistant, maybe doing some bookkeeping work, and we have seen cases where people are providing a service that's very much outside of what they're buying a policy for. If you have a claim allegation that is not related to being a dental assistant, then the policy won't respond. And so you won't get any legal defense costs at all. So if you are taking on other types of services, and bookkeeper is one that comes to mind, or maybe you're doing something with a side business at your home and you're selling certain things through Amazon, that type of activity is not covered because it has nothing to do with being a dental assistant.
So let's just examine that a little bit further. We have different legal scopes of practice in Canada for this profession based on the province where they're practicing. So for example, there are some treatments that a dental assistant in Ontario might not be legally allowed to do, but they might be allowed to do that in Saskatchewan, for example. So let's say a dental assistant is doing something that's within the profession of dental assisting, but outside their provincial legal scope of practice. Would that same situation apply as you just described?
Yes, so if you have someone from Ontario who's a dental assistant and they go and work for 60 days or a short period of time, perhaps in a place like Saskatchewan or Alberta, where the scope of practice can be different, and they provide services in one of those provinces, but they don't hold a registration or a license to practice in that province, then the insurance company would decline that claim. They have to be licensed and registered in the province where they provide the service, where the claim is emanating from.
Okay, okay. We also have seen some situations where a dental assistant, for example, and I'm not picking on Ontario or Saskatchewan dental assistants here, but let's say a dental assistant in Manitoba is they have a limited legal scope of practice, and there's another activity that's legal, let's say in Saskatchewan, but their employer asks them to do it even though they're practicing in Manitoba, where that skill is not part of their scope. I just want to make sure that people are clear that beyond their scope, anything beyond their scope voids their coverage. Is that correct?
Yeah, it's an important thing to remember, that it would void their coverage overall. That's a scenario that thankfully we have not seen yet overall, and that brings into play a whole other host of issues related to the way a supervisor or the owner of a clinic is behaving overall, and that could result in perhaps disciplinary action or something else that comes from that overall. This policy does provide protection for a disciplinary matter that's brought forward by a regulatory body. So that's another really valuable feature in this policy that you don't always get if you just buy something in the regular marketplace. If there's an allegation of a regulatory body that you have done something offside or there's been a complaint lodged against you, then you have coverage for that under the policy as well. There'll be legal defense to protect your reputation and protect your practice.
Okay, great. Thank you for that clarification. I think that's really important for dental assistants to know, where their coverage ends and what their responsibility is in terms of understanding those limits. So I also have one last question, and that is, in the event that an allegation or a claim is made against a dental assistant, what is the first step that they should take? What should they do? What is step number one? I can imagine that these situations involve a lot of stress, a lot of worry, and a lot of unknowns. And so I think clarifying for our members, really what is step one? What should they do would be really, really important.
Stephanie, I'm really happy that you're ending on this point. It is so critical. And I'm going to use an example as well as to why it's so critical. If you have an allegation brought against you, and it might not be an actual statement of claim. Statement of claim is usually pretty obvious because you're being served with something that's a big document and there's going to be financial damages people are looking for. But sometimes it can be an allegation where people send a very strongly worded email saying that they are not happy, they are going to be seeking a lawyer, they are going to be bringing forward an allegation, they want compensation. Anytime where you have someone who's making a demand of you as a result of your services as a dental assistant, your next step is contacting ProLink. And our firm is well versed and ready to take on any type of question that comes in related to an allegation brought against you. We'll talk it through with you. And if we say, yes, this is a serious matter that sounds like it's going to result in a future claim, then we connect you in with the lawyers at the insurance company. The insurance company is called Trisura. They're a phenomenal company that is focused on protecting healthcare practitioners across the country. So that's step one, contact ProLink. Step two, we then evaluate it with you, put you in touch with a lawyer from Trisura. Now, here's an example, and we've seen this on multiple occasions. Here's what you do not want to do. You do not want to hire your own lawyer and then have that lawyer start to investigate. You're going to be paying that lawyer out of your own pocket because you haven't told the insurance company or ProLink. And then after you incur $5,000, $10,000 in legal costs, contacting ProLink saying, I had this claim brought against me. I hired a lawyer and they're defending it. can you please have this bill paid for by the insurance company? That's not how it works. You would not get that covered by the insurance company. The insurance company, the contract between you and the insurance company is that they will be made aware of the claim so that they can defend you. And they need to be aware of it. They don't just take the invoice or the lawyer that you've hired and then pay the bill. And this has happened on multiple occasions for all different types of professionals. So step one is critical.
That's really important. I think that that's very, very important information for our members to have. They need to contact you first. This is not a reimbursement type of situation. So that's really, really important. So thank you, Derek. I really appreciate your time today. I think those are all the questions I have today, but certainly we'll reconnect with you if we hear more or need more information. And for our members who are watching today, if you would like more information on the CDAA and ProLink program, you can find all your information on the CDAA website, and the link will be put up on our YouTube channel after this video. Thanks, Derek. Have a great day.
Thank you. Take care.